Yes, welcome to my live video session. I, Suhail Ahmed, will be with you next couple of hours, next couple of minutes, regarding a couple of important update, immigration law, especially the amnesty for Overstayer or undocumented migrant. I'll speak about the issue regarding the benefit claim or the universal credit for those EU national who has pre-settled status, because as you know they denied. The recent case law come from the European Court of Justice. I'll speak about a basic Zambrano care rights, those parents of British citizen, those parents of British child. I mean the British carer, carer of British citizen, those who are can apply under the EU laws. All this issue I'll discuss. Before that, let me take a short break, and after that I'll come back again. Yeah, so it is a good news for I said those migrant or overstayers who are an issue of regarding their right to stay in the UK. As all of we all expect that when Boris Johnson enter in number 10, he will give amnesty for those overstayers who is in the UK for a long time. However, when he entered the Home Office in number 10, then there were no any state, no one, neither the Home Secretary or anyone else gave any statement regarding the amnesty. Rather than they gave the statement in 18 March 2021, and before that as well, about whether the government has any plan to give amnesty or not. Now, there are two petition was circulated in internet, in Facebook, in different media regarding a petition to the parliament for amnesty, and one of the petition was rejected, which was related to COVID. But now one of the petition that grant urgent amnesty for those of us that reach over 100,000 signature, and that trigger a debate in the parliament. So to Monday, that is 19 June, 6 o'clock, there will be a debate in the parliament regarding whether government should give amnesty for those overstayers or undocumented migrant. And if debate hopefully, I don't know yet the Conservative government position, but I do believe the Labour will support. So in that case, the discussion will be attract the more attraction for the media, for parliament's member, as well as the whole country. And I don't know whether the parliament will approve it, but if the parliament approves, then it's a good news. But I don't know yet. But still, this is a great achievement for those who started this petition, that triggered to a debate now in parliament. So parliament will discuss about the whether the government should give or shouldn't give the amnesty for those overstayers or those what you call undocumented migrant. We can't tell. So that is what all about. So 19 July, 6 o'clock, please watch the debate. I'll try to share this debate in my live program as well, and as well as what role you play if you are watching this program, if you are an undocumented migrant, or you are a citizen, or you are a foreigner, or you are a migrant, whatever it is. We all have a responsibility for the community, for those people who are suffering in the UK, just lack of their leave to remain. You can, whoever watching my program, you can send an email or contact with your local MP and and ask him, request him, invite him to raise a question and support this petition and play a role in the parliament to give an amnesty for those overstayers. By the way, the conservative government was there said they are not going to give amnesty for overstayers. So be careful as well, the viewers, that don't expect, because some people in this country always exploit the rumors. So many people are expecting and they are advising the client, their people, that government going to give amnesty. So bring the file, bring the money, we'll make the application. These are the obedience you need. This is not the case yet. So be careful, because we saw during the Windrush generation in my back home, in my hometown, I saw people are taking money. So you have to be very careful. The government has no plan yet, so you don't need to make an application. You don't have any opportunity yet. But this is simply a debate will be in parliament whether overstayer or the undocumented migrants should get amnesty or not. Now, what the government position is, when the petition was launched in 18 March 2020, the Home Office made a statement. They said, exactly, I'll quote, "The immigration rules already provides for undocumented migrants to regularize their status where appropriate. But such a provision would unduly reward those who have not complied with the immigration law." So it looks like that the Home Office or the government has no plan to give amnesty, but still, let's try from now on, from 19 July, and then we'll fight for it to get an amnesty for the undocumented migrant. So that's what's news. If you want to watch the program, or you can watch it online or from YouTube, Parliament, or in Parliament BBC, in Sky as well on your TV. Now let's move to the EU citizen regarding the right of universal credit. But before that, what I want to give brief about Zambrano Kara, because I spoke a lot about those who basically providing care for a British child or British citizen, whether you are a parents or anyone who, as soon as you provide the care to a British citizen, whether a child or adult citizen, you can apply for settle or pre-settle status under EU law, under the EU settlement scheme. Now this, as I already gave, that it is expired on 30 June 2020, but however it extended by a consent order up to 6 weeks from 1st July. So you have up to middle of August to make the application. If you are a carer of a British child and you got leave to remain even after 10 years route, now you can make the application and you will get your leave to remain by 5 years. You will get your indefinite leave to remain by 5 years. You don't need to pay any home office fee. You don't need to pass life in the UK test or English language test. So all these advantages, a lot of advantages as EU nationals enjoying in UK, what British nationals cannot claim or other nationality people cannot claim. So you can enjoy all this right under EU settlement scheme. However, this application, if you made a Zambrano carer right application under EU settlement scheme for pre-settle or settled status, this is not granted that you will get it, because this application we are advising based on a decision of the High Court. However, Home Office appeal against the decision of High Court to Court of Appeal. So if the Court of Appeal overturn the decision of the High Court, then unfortunately all the application will be dismissed. However, if even they're dismissed, that will not affect your current leave to remain if you are already in the 10 years route. Now moving to Fatila case, what the EU citizen or EU family member, those who came in the UK after transitional period or before transitional period, even after the Brexit, and those who made a claim for universal credit or benefit, then the DWP refused the benefit, and then what the current issue is, if anyone applying or those who already applied, all the claim to universal for to DWP for universal stay, because there is a case, because the Home Office position is the DW position is that those who got pre-settled status after Brexit, they are not habitual resident and they cannot claim mean tested benefit from the government. So what that was challenged, and that means in simple, those who have got pre-settled status under EU settlement scheme, they cannot claim universal credit because they are not under EU law, and they cannot claim the universal credit. That this was the Home Office position, is they cannot claim mean tested benefit. But that was challenged by Romanian nationals on the ground that this discriminate among the EU citizen and among the British nationality based on nationality. Now that appeal go to the High Court, and then High Court give a decision that in any case that the discrimination is based on the nationality, which is so far this decision came in favor of the applicant, and then the DWP appeals to the Court of Appeal, and or vice versa, I'm not sure. But the thing is that this decision, that the pre-settled status who applied, those pre-settled status holder for benefit, their whole decision is pending in universal credit, and they stay the decision and waiting for the decision from the Court of Appeal. Now, what the outcome may be, that exactly why I'm discussing this now before the decision Court of Appeal, because there is a case law exactly similar situation. A decision came from the Court of Justice, from Court of Justice, and this is the highest court of European Union. They say the case number is C70720, CG Department of Community in Northern Ireland, where they say the denying benefit of EU pre-settled status holder justified, because the principle of EU law is that is you cannot make, the member state cannot discriminate the EU nationals and their nationals based on the nationality. However, it can be discriminate if it is justifiable. So EU national, those who got pre-settled status in the UK, they got pre-settled status under the UK national law, not under the EU law. In that case, they cannot claim the main tester benefit, and they cannot bring this issue that is discriminate me. But in any case, Court of Justice said that it is not, the discrimination is justifiable. That means based on nationality, the DWP or any other authority can discriminate EU nationals on the basis of their residence, that is if they have pre-settled status. What the Court of Justice also said that just based on pre-settled status. However, if they have children, that the children have right to live with dignity with their parents, and on that point, because of the children, there might be a chance that the applicant can get benefit. So that decision will impact the next Court of Appeal decision, which is pending in the UK. Many EU citizens who applied for who got the pre-settled status, and they came in the UK after Brexit, and they applied for benefit. Their benefit decision is stay, because the DW said we'll make a final decision, and when the Court of Appeal decision will come. So if you are in that situation, then I'm in my realization that same outcome will come as the decision of the Court of Justice, that is the refusal of universal credit will be justifiable. So this will happen, and maybe because normally the Court of Justice decision is binding, and the similar submission will be made by the DWP. However, you can still claim a universal credit if you have children, and if you live in the UK on other basis rather than only for pre-settled status. So what are the other bases can be? For example, if you have a Zambrano, if you are a Zambrano carer, because if you because a lot of years, for example, if you live in the UK on Zambrano basis, if you live in the UK on Ibrahim basis, Ibrahim, this case law from the Court of Justice, European Court of Justice. If you live on the UK 10, when your EU child is in full-time education, then you can claim that you are a habitual resident. You have right to live in the UK under the outcome of the Chen and Ibrahim case. And also when you provide care to a EU child, and if you live in the UK on that basis, you are a carer of a EU national, who is called Zambrano carer. And all if you are on all these route, and or if you live to remain on that basis, then you can claim universal credit, because pre-settled status is different than other basis. And both case and the DWP guidelines, if you can claim leave to remain on the basis of other grounds such as Zambrano carer or Ibrahim John or any other route, you can claim universal credit. Only DWP hold the universal credit for pre-settled holder. But in any way, we are still waiting for the decision from the Court of Appeal, and once the decision come, then we'll see whether EU citizen can claim universal credit or not, those who came after Brexit. Now, Zambrano case, this is a very popular topics among migrant community, because those EU nationals, as I said, who are in the UK on limited leave to remain on 10 years route, on the basis of a relation or a father of a British child, or a mother of a British child, or a carer of a British child, or carer of a British citizen, normally you get 10 years route. And every 2.5 years, you need to extend your visa. Now, following a decision of the High Court in 17 June, they said, the court decision said basically that those who are a carer of a British child, they are a Zambrano carer, and they can apply under EU law. That means you can apply under the EU settlement scheme as a carer, and you will get a pre-settled status or settled status for 5 years. And after 5 years, settled status you will get, then you can apply after 1 year British citizenship, if you already spent 5 years as a carer, or if you are right now, if this is your first application, and then that case you will get 5 years leave to remain or pre-settled status. In that case, after 5 years, you will apply for settled. So it's very easy. You don't need to pay any home office fee. A lot of requirement to live in the UK. You don't need to do it. You can claim benefit, all these things. However, this application is not a granted that you'll get it, because the outcome of this decision will come in the decision of the Court of Appeal. Because Home Office, we are advising clients to make an application on the basis of the High Court decision, but Home Office appeal against the decision, and the appeal is pending. Now, if the decision overturned in the Court of Appeal, then all the application will be dismissed. However, it will not affect any of your leave to remain, current leave to remain under Appendix FM. So you can make application. It is advisable, because this might give you more chances to get ILR early and less expense. But it is a free application. You don't need to pay an home office fee. So I discussed a lot of question about it, but what I want to make clear today, the procedure for make this Zambrano care application. This application eligibility is you have to be a carer, state with. If you're just a father, or if you're just a mother of a British child, you will not get it. You have to prove you are a carer. So you need to provide evidence that you are a carer. The evidence means document from GP. You can write a letter, you can take a letter from the GP that you are the person in primary contact. You take the child to the GP appointment and look after. So you need to get a letter from the GP. You need to get a letter from the school. You need to get that you take the children to school. You bring them back. You are the person in primary contact. You attend the parental meeting. So all these things should come to the letter. You need to provide evidence that the old letter come from the hospital in your name, or parents of your child, or some whatever it is, and some other. If you have any social care involved, you take a letter from them, from local authority, wherever. You are the person who addressed all the letters. So these are the basic evidence of a carer. So if you can provide, of course, your name has to be in birth certificate as well. If you further by, it's not necessary in other case where adult you are providing a carer, as soon as you satisfy all these requirements. This is what the eligibility requirement is. And the next one is how to apply. Most of the application, whether EU law application or domestic law application, is a PEP online application. However, Zambrano Care application is not online. So what you need to do, you need to download a paper form. Then either you can write it on computer and print it, or print it and then write by pen, by hand, so handwritten, and then you can send it by email, the email address on the form, to the Home Office. And then within 10 days of the application, you need to send all the supporting document to the Home Office. This is how the procedure to make the application. As I said, what document? In addition to that, there's a list of document in the form itself. So you can see all the document in the form, and whatever you can send it. Now, the outcome, the Home Office will not make a decision yet, because once the court of decision come from Court of Appeal, then the Home Office will start make the decision. So I hope you got your answer. And then I'll give a couple of updates today about the immigration, because I came after a quite long time. So next, graduate route. As you say, as you know, I gave update before, and many people and many of you know about it, that PSW, which is post study work permit, that if you come in student visa, once you finish your graduation, you will get 2 years work permit. That started from 1st of July. So those who will be graduated, those who already graduated, and you can apply now for PSW, which is post-study work permit. You will get 2 years automatic work permit. The condition is you must be graduated in the UK. So you need to do a course. You have to complete a course, either master's or a graduate course. And then before your tier 4 visa expire, you need to switch to graduate route. So you must be on a student visa. But generally, the UK Home Office issue visa always 2-3 months extra, so that you can get your result, and then after 1 month you can leave the country. So in standard route, you will generally get your result before your visa expires. So you need to make the graduate route application before your tier 4 visa expire. Of course, you must not breach an immigration law. This is the main trick for, and very important for the Asian, Bangladeshi, Pakistani, and African student, because many students came here, they just work 20 hours, more than 20 hours, 40 hours full-time, 2-3 job to maintain themselves, to send money for the university, colleges, and this will be trigger a refusal of your graduate route application, because you will be in breach of immigration law. So those who will came in the UK, you must comply with the condition of your visa if you want to get PSW, because Home Office will refuse a lot of applications just because you was in breach of immigration law. So these are the requirements. In terms of dependent, also this is a issues which arise once the graduate route introduced by the Home Office 1st of July. That is dependent. You cannot bring your dependent once you switch to graduate route, unless your dependent was with you when you was in the UK as a student visa. So this is very unfortunate. So if you don't have dependent in the UK currently while you are a student, you cannot bring them once you switch to a graduate route. So this is also discriminated, because in the UK, if you are on a student visa, only those who are doing postgraduate course, they can bring their dependent in the UK, and then once you switch to graduate route, you can switch them as well to graduate route. But undergraduate student cannot bring their spouse, and accordingly they will not be able to bring their spouse, bring their dependent, while they will switch to graduate route. So this is a big issue. That means only postgraduate course, those who are doing postgraduate course, they will able to keep their dependent and will able to maintain their family life. So it's a good news anyway, because PSW was used to be before 2012, and Home Office, the Home Secretary Theresa May, who lost her job as a Prime Minister, she introduced she withdrew this PSW from the student route, unfortunately. But now current Home Office again introduce same route. I think because of the economy and the labor market of the UK, because UK come out from the EU now, a lot of EU citizens are moving to their home country. Now they need people to run the industry, economy, businesses, and probably they are trying, maybe hoping that more talent people from around the world will come to the UK. And as you know, they introduce also the new work permit, point-based system, which is also important for those EU nationals and non-EU nationals who want to come to the UK, because now this all the immigration rules is same way applicable to EU nationals and non-EU nationals. So wherever in the world you want to come to the UK, you need to achieve 70 points. How you can say, because this is a point-based work permit, so if anyone want to come to the UK for work permit, first you need to find an employer. Okay, you don't need to go any lawyer to get a work permit. Don't you go any person or anyone who said that give me 10,000, 20,000 pounds, I'll give you work permit. This is, be careful, don't go them. Okay, because you have to find your employer by yourself. Wherever now, technology is spread everywhere. In Bangladesh, or if you live in Nigeria, in a village of Ghana, you can contact with the employer in the UK. So you can need skilled people, especially IT people. NHS need doctors, nurses from overseas. Contact to the recruitment agency, send your CV to employer. You can see they are recruiting people. Send your CV, contact with them, send them email, and then if they like you, they will offer you a cost letter. And what you need to do is you need to achieve 70 points. Now I explain you how you can get 70 points. Is first, if you get a job offer from an approved sponsor means Home Office have a list of sponsors in their website who those sponsor can offer a job to a foreigner. So if you get a job offer from an approved sponsor, you will get 20 points. And if the job is at appropriate skill level, you'll get 20 points. Now, Home Office published a skill worker job list in the appendix of the Home Office immigration rules. At the same time, the shortage occupation list as well. So with the shortage occupation list, there is a list of skill jobs. So if your job on that skill job list, then you'll get 20 points. If you can speak English B1, you will get 10 points. So you got 50 points. And then the rest of 20 points will come from your salary. So if you get 25,600 pound, 25,600 pound or above, you will get 20 points. 70 points, job done. You achieve 70 points, you will get visa, one work permit, 5 years, 3 years, and after that 5 years, then you can apply for indefinite leave to remain. After 1 year of indefinite leave to remain, you get your passport, naturalization, British citizenship. So that what is all about work permit. So it is not something that you can buy money. So you have to be careful. Don't pay anyone. This is not for money. You will not get any money. You will not get any point if you pay 10,000 pounds to someone, right? So you have to be careful. You get your point when you have a job offer. When you have a job offer at appropriate skill level, you have that skill. You have salary offer, which is 25,600 pounds. You'll get your work permit. Good luck for everyone who is looking for a work permit in the UK. UK need a lot of talent people because skilled people. A lot of job vacancy here. If you have that skill, welcome to this country. It's a very nice country, of course. So you can come and make your home. Now, when any news come or any advantage come, like working holiday maker in previously, student visa tier 4 in 2012, 2011, people starting abusing the system. So this is the main concern and main issue for our community. And many people do fraud. Like in Windows generation, I heard in my country, people taking money from many people, 5,000, 20,000 taka, 100,000 taka, whatever it is. They said, oh, your grandparents were, your uncle was in UK, you will be a British citizen. You have, and so no one knows if this is they take money from each other. Okay, if you get, so what or not, 50,000 pay, maybe all my family will be British citizen. So people have a hope. I know not a single people come from Bangladesh or Sylhet to in the UK on that winter generation route. But in the middleman, a lot of people made thousands of pound or Bangladesh lakh taka. Bangladesh, the people made it from the our people. So again, in the work permit come, a lot of people making contact 10 lakh to 20 lakhs. So be careful from this touts. So if you are qualified, if you have that skill, contact directly with the employer, with the sponsor. A lot of big multinational company, they need people from India. A lot of skilled people came all the time. I met when I go out, I see in NHS, in IT company, a lot of Indian national coming to the UK on that on this job. I do welcome, and all the over the people, all over the world, people are welcome this country. So work permit, of course, after the pandemic, when the business will grow, is a great opportunity. So if you need help, contact with these employer, this sponsor license. What any precaution you need to do this is very careful, I think, before you send your CV or before you make an agreement. Go to the Home Office website and see whether this particular sponsor is registered with the Home Office or not. So last point again, I want to remind all of you that about Amnesty. Monday, 19 July, will be a debate on Parliament whether the government should grant amnesty for overstayers or undocumented migrant. Now, this debate is very important. So everyone in our community should play a role. What you can do, watching my program, you can send an email or a call or send a letter or make an appointment and see your MP and ask him to contribute and play a role and support this debate to give the amnesty for overstay or what is called undocumented migrant, because after a petition launch last year is crossed over 100,000 signature, and now this is a matter of debate for the House of Commons, and that debate will be 19 July 6 p.m. Please watch it, share it, and support it. Everyone who ever watched my program, thank you, all of you. I'll be live on NTB Sky 780 tomorrow, 3 p.m. To 4 p.m. I'll take direct calls on NTB if you have any question or if you need any help on any matter, whether immigration, family and litigation, or any other legal affairs, divorce, child matter. I'm happy to give you an answer. You can watch tomorrow at 3 o'clock to 4 o'clock at Sky 780 NTB Europe. All of you, good luck and take care, everyone.